Hello and good afternoon. I would like to welcome everyone to today's webinar, an introduction to PERM recruitment. Before we get into the main presentation, I would just like to go over a few housekeeping items. Today's session will last for about 45 minutes, and that includes an audience Q&A session at the end. So we highly encourage you to ask some questions throughout the presentation, and we will try to get to them at the very end. Please keep in mind, however, that we can really only answer general questions regarding green cards and the PERM process. We cannot get into specifics over the air. In those instances, please consult your immigration counsel for further information. Additionally, this webinar is being recorded, and everyone will receive a link to download the recording after today's live session. You will also receive a link to download the accompanying slide deck, as well as the SHRM and HRCI continuing education credits. All of these materials will arrive in your email inboxes tomorrow afternoon, so please keep an eye out for that message. And if for whatever reason you don't receive it, just please let us know and we will send it over your way. And finally, please excuse any potential audio or visual technical difficulties. As I'm sure most of our attendees are as well. Louis and myself are still, we're all remote. We are not anticipating any issues, but just in the event, apologize for any inconveniences. And again, you will receive a recording. So now I'd like to talk a little bit about Envoy. For nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 150 countries, has grown 37% year over year, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And I introduced him a few seconds ago, but now I'd like to formally introduce Louis Massard, a managing attorney with Global Immigration Associates. Louis provides counsel to employers of all sizes across a wide range of industries in obtaining non-immigrant and immigrant benefits for foreign national personnel. Louis is experienced in leading compliance projects and due diligence initiatives related to corporate structure changes such as mergers and acquisitions, downsizing, reductions in force, and creation of successor in interest entities. Louis routinely prepares and delivers training presentations to a wide range of audiences, including human resources leadership, recruitment professionals, and visa beneficiaries. And prior to joining GIA, Louis practiced immigration law at a boutique law firm in North Carolina, where he provided counsel to employers, families, and individuals. Louis, thank you so much for joining us today.
Well, thanks so much for the kind introduction, Eric. It's great to be joining you guys today.
Awesome, thanks, Louis. Louis, we have a great presentation ahead. I just want to quickly also go over our agenda today. We got a couple of different sections. We're going to start looking at some green card sponsorship trends. And then, Louis, I'm going to turn things over to you for the meat of the presentation for the PERM labor certification process and the additional sections. And finally, just want to leave up this quick legal disclaimer slide. And I did see a question come in. Yes, you will receive the slide deck in a PDF format. Okay, so with that, let's open this presentation by looking at some very interesting green card trends in 2020. So a couple months ago, we surveyed over 400 human resources professionals in our 2020 Immigration Trends Report. This was conducted in conjunction with the Harris poll at the end of 2019, and it was published in February of 2020. And 71% of respondents said their company has sponsored a foreign national for permanent residence. And we see that's up from 66% in 2019, and it's back to the level it was in 2017. Diving deeper, we were curious to know when companies typically started the green card application process for their sponsored employees. And we see here that 81% they said they start their process within the first year of service. And if we break that 81% down even further, we see that 26% start the green card process immediately, 20% start after 3 months, and 18% after 6 months, and then 17% after 1 year of service. So these are very, very interesting trends. And we see that 81% is a huge jump from the 2019 when it was only 66%. And so now I'd like to kind of gauge our audience, and I'd like to pose the same question to our audience. So when does your company typically start the green card application process for your sponsored employees? And in a few seconds, you're going to see a poll appear on your screen. All right, so everyone should see a poll on their screen, and I'll leave it open for about 30 seconds. And just really curious to see how you respond to this poll question. Give it about 10 more seconds. All right, let me close it. All right, so let me share the results with everyone. Awesome. So we see here, almost in line with what we're seeing in our trends report, 50% started within the first year of service. 42% of you said after 3 years, and then 8% after 5 years of service. So very interesting to see, and thank you for participating in the poll. All right, and as we move along, this next slide contains some recent news. 2 weeks ago, President Trump signed a presidential proclamation that temporarily suspends immigrant visa processing for certain applicants outside the U.S. And Louis, I'd like to bring you in on this one. Can you break down this proclamation for us, and what exactly does it mean?
Sure, absolutely. So, preceding the signing of this proclamation, I think everyone had received news reports about a tweet indicating that immigration would be suspended. Right. So, with such a broad statement, everyone, was understandably alarmed. But the resulting proclamation, I think, was unanimously met with, just a view that it was pretty underwhelming. There are significant carve-outs from this proclamation, most notably that those inside the United States, right, those pursuing a process called adjustment of status, which is the process of applying for a green card while inside the United States, which, comprises of, I would say, bordering on 98% of green card applicants do so through that, or at least employment-based green card applicants do so through the adjustment of status process. They're currently inside the United States, and their employer is seeking to sponsor them for permanent residence. Right? Adjustment of status applicants and those applying from inside the United States were not impacted by this whatsoever. Furthermore, this proclamation really sort of wasn't much of a departure from the status quo, right? It really serves no significant change or departure from, again, the status quo. The Department of State the folks the branch of the government who runs the consulates abroad had already suspended operations on March 20th, right? So in order, in essence, to say that, immigration was, ceasing, right, or that it would be suspended, it was already just sort of business as usual, right, given the COVID-19 crisis and the existing suspension of consular operations. So long story short, the product of this was really, there was no real cause for alarm as it pertains to most employers. Again, adjustment of status applicants, those employees currently in the United States applying for green cards, not impacted. And B, consulates were already closed at the time that this was signed, right? So I think this is all sort of welcome news for employers, which I think allows us to sort of move forward and look at what the PERM labor certification process really is, and how employers can continue to proceed in those sponsorship efforts.
Great.
So what is
Thank you for that.
Yeah.
Oh, no, I was just saying, Louis, yeah, thank you for that detailed breakdown. And yeah, with that, I'm going to turn things over to you then to take us over. What is the PERM labor certification process?
Sure. So the PERM labor certification process, what is it? It's, in essence, it is the most common preceding step in the green card process for employment-based immigration, right? The PERM labor certification process is completed entirely through the U.S. Department of Labor, whereas basically every other immigration step is either you're dealing with either USCIS or the Department of State, as we've just discussed. All right. The purpose of the PERM labor certification process is to serve, in essence, as a test of the labor market to ensure that U.S. workers aren't being negatively impacted by companies' efforts to employ a foreign national employee, right? It requires that companies engage in effect like a bona fide effort to fill that existing position, right? The one that you've identified for your foreign national employee with a U.S.-based worker. So if you proceed to the next slide, we'll see that when we discuss, is this case EB2 or EB3, what we're really talking about are different immigrant categories, right? Different green card categories that correspond typically, and most importantly, with the requirements for the sponsored position. A vast majority of EB2 and EB3 green card categories require this labor certification step. And when it all sorts out, right, with all these steps that we're going to discuss, completion of these labor certification steps can vary for many different reasons. But we estimate that it typically takes about 10 to 11 months. So here we're going to engage in just an overview of each individual step that the PERM process, the PERM labor certification process comprises of. The very first step in any labor certification case is that we have to seek from the Department of Labor a prevailing wage for the sponsored position, right? For that green card position that you've identified and that you want this person to fill upon approval of their green card, right? And we have to do this before even the recruitment stage, right? We will ask employers for the job title, job duties, the minimum requirements for the position, the locations of the job, and any travel requirements, right? So this is, again, these are the facts that we compile and refine and send to the Department of Labor so that they can look into their database and say, this is what we believe to be a prevailing, right, a fair wage for this position, given these requirements. So throughout the stage two, we will also, so an employer will provide us with these minimum requirements. And in essence, we conduct our due diligence at this very first stage. And we will review the requirements that an employer provides to us, and we compare them against what the foreign national, like the intended employee, what their experience and credentials actually look like, right? So if a position ostensibly requires, say, a bachelor's degree plus 5 years of experience, we will evaluate that foreign national employee's degree to make sure that it's equivalent to a U.S. bachelor's degree, and that they in fact have the 5 years of experience that an employer typically requires for the position. Again, the driving standard for this is the minimally acceptable requirements for the position. So when we say that we want to conduct a test of the labor market, right, and conduct, recruitment as you normally would, it's sort of understood that recruitment in the PERM context doesn't really follow how an employer would typically look for and search for an employee, right? Typically, an employer wants the best qualified person in a pool, whereas in the PERM context, we're asking employers to give us the requirements for a position that are the minimally acceptable requirements for the position, right? So any sort of preferred qualifications are typically struck from the job requirements, right? Any sort of aspirational skill requirements are struck from this position, right? So we'll go back to an employee and say, can you provide evidence, for instance, in the example that I just brought up, are you going to be able to demonstrate 5 years of experience and familiarity with all of these listed skills before we would ever file a prevailing wage request? We also encourage employers at this first stage to do a bit of homework that's going to enable us to sort of proceed to subsequent stages, right? For example, if an employer doesn't already have a PERM login, a DOL PERM account login and profile created for Global Immigration Associates and my colleagues and for our firm in general, we ask that they complete those steps, complete that step at this first stage. Then also creating a state job order login account, right? So if the position you've identified is, say, in Michigan, the Michigan Department of Labor runs their own sort of job search website, and that account must be created as a necessary and required component of the recruitment that we'll conduct after the prevailing wage determination has been issued. Business necessity documentation isn't typically required in every case, but it's something that is good perhaps to have on hand and to keep on file. So once we file the prevailing wage, so we've narrowed down the requirements for the position. These are the requirements for the position that are going to sort of stick throughout the life of the case. We've confirmed with the foreign national employee that he will be able to, that he meets all the requirements for the position, right? He has the required bachelor's degree and it's an equivalent, and he possesses the 5 years of experience, and he'll be able to demonstrate all that through the course of experience letters from prior employers. Once we've confirmed all that, we will file the request with the Department of Labor. the Department of Labor will then respond with their determination. They've looked at our requirements, they've looked at the location, they dig into their database, and their output is a prevailing wage determination, right? That will typically be issued between 2 and 4 months. And the important thing to remember about that determination is that an employer is only required to pay that prevailing wage determination. Say it's much higher than what they currently earn. At this stage, it sort of really depends on where the applicant is from, right? So if your, employee applicant is from India and they're EB2 or EB3, employers can look at that prevailing wage determination and know that they won't actually have to pay that prevailing wage, that higher prevailing wage, until probably 8 or 10 years into the future. If your foreign national employee is, say from a place that's not India or China, that requirement would be triggered much sooner into the future, right? So probably in the course of the next 18 months, the company would be required to pay that higher prevailing wage determination. So with this, we can essentially proceed. We receive the Department of Labor's prevailing wage determination, and say it's lower than what you currently pay that employee, or the employer accepts that higher prevailing wage determination, right, according to the varying timelines. And with that, we can proceed to the recruitment stage of the PERM labor certification process. So the PERM labor certification process has, it's very closely regulated and delineated by the Department of Labor regulations, right? And they have to be prepared in compliance with what the regulations say and over a timeline that the Department of Labor sets forth in regulation as well. So for professional positions, we have to advertise in 2 newspaper advertisements on consecutive Sundays. We also, as we discussed previously, have to post on the state job orders website for at least 30 consecutive days. A paper notice of filing has to be posted at the job worksite for a period of 10 consecutive business days, right? So you have to omit holidays, omit weekends, omit days that no one's in the office. And then in addition to that, employers have to complete 3 additional discretionary forms of recruitment. There's a list of acceptable recruitment for these discretionary forms, and they include things like TV or radio ads, job fairs, job search websites. This is a process that we help every employer manage and manage closely, such that through our recruitment vendors, oftentimes the only form of recruitment that an employer will have to complete themselves oftentimes will just be the internal paper notice of filing, right? Where we ask, say, a human resources professional to print out the template that we've provided them with for the internal notice of filing, post it up in the office, set a reminder to take it down, sign it, and upload it. All of the other remaining recruitment forms, presumably, could be, and oftentimes are, completed by myself and my colleagues at the firm. A very important thing to remember about the PERM recruitment process is that it can only be conducted by the employer and immigration counsel, right? So throughout this entire labor certification process, the Department of Labor is very careful to point out that employers and counsel need to take every step to avoid any sort of interruption or interference by the sponsored employee, right? So naturally, there's very, very little that we'll ever be able to disclose to your foreign national employee about how recruitment is going. All right, so we move on here, sort of under the assumption that we've completed all of the required recruitment steps. We have the proofs back from the newspapers. We have, we've taken down the internal posting notice, right? There is a requirement, set forth in the Department of Labor's regulations that recruitment has to be completed within 180 days. But then once all ads have finished running, right? Let's say the very last thing to run is, that one Sunday in the Sunday newspaper, in the local Sunday newspaper. We cannot file the EPA 989 labor certification, the step that we're going to talk about in the next slide effectively, for 30 days. What we call it is the sort of 30-day cool-off period. And what this is intended to capture, it's intended to allow qualified U.S. workers the opportunity to respond and to apply to the actual position and to afford them that opportunity. So these applicants, they're asked to submit resumes, right, and complete screening questions. And here, we can guide an employer on what the acceptable screening and disqualifications reasons can be, but we cannot complete the screening and disqualify them ourselves. So it's an important distinction. Here we've set forth the acceptable, many of the acceptable disqualification reasons. They have to be what's called job-related reasons for disqualification, right? So in other words, saying that someone is not a good fit for the company is too vague, not acceptable. Failure to meet the minimum requirements for the position, on the other hand, if they've admitted that they don't possess a bachelor's degree in the fields that you require, or they fall short of the 5 years of experience that's minimally required for the position, then that's acceptable. If somebody has submitted a resume and you follow up with them and they indicate that they've already taken another job, then that's an appropriate grounds for disqualification. If you contact someone who submitted a resume and they indicate that they're in H-1B status, they can be disqualified on the basis of that, because effectively they fall outside of the definition of a U.S. worker, right? So you can't disqualify, I guess maybe to state it otherwise, U.S. citizens and current green card holders cannot be disqualified on the basis of their status. They fall within the definition of what a U.S. worker is, but anyone else on any sort of temporary visa status, right, whether they have an EAD or say they're in L1 status or an H-1B or say they're just F1 OPT, all of those temporary statuses, applicants who are in those temporary statuses can be simply disqualified on that basis. All right, so we've completed recruitment. We've let the 30-day cool-off period pass. We've screened all applicants. We've found, we've provided acceptable justification for their disqualification, or in a lot of cases, there simply are no applicants for the position. We can finally move on to the form ETA 989. This is what we commonly refer to in shorthand as the PERM. Here we are simply compiling a lot of the same, and this is a compilation of the two preceding steps, right? What is the prevailing wage? What is the offered wage for the position? Tell us about the requirements for the position. Tell us about the recruitment that you've completed for this position, and tell us about the employee applicant who you intend to sponsor for this role, right? And also tell us about their qualifications, their credentials. Where do they go to school? What's their qualifying experience for the position? So you'll see that this is just a a long-form compilation of the preceding steps, the prevailing wage request stage and the recruitment stage. And this is ultimately where the employer certifies that no qualified U.S. workers were identified for this position in the area of employment. So the timeline for adjudication at this specific stage is roughly 4 to 6 months. Once submitted, a PERM application will be certified in that time. It could be audited or simply denied. PERM certifications are like tax returns in the sense that they're attestation based, right? So a percentage of PERMs are audited. We're not asked to provide, all of the proofs of the recruitment that we conducted when we file initially, but when audited, that's typically what the Department of Labor is looking for. They're saying they're effectively asking to check our work, where we make this attestation, and say a few months after filing, they respond with an audit. Most are, randomly audited, right? And they're just asking us to say, show us the resumes of the people that applied, if any. Show us your recruitment proofs. Just show us that you did everything as you said you did. So as we just discussed, it's, the Department of Labor, if I had to guess, their audit rates typically border anything, I think anywhere between 15 and 25, maybe 30% of filed cases. Certain employer profiles, I think, are more susceptible to audit, right? I think the worst that can happen is that the Department of Labor will, issue an audit and you're not able to substantiate the things that you've certified in the initial filing. What, probably the worst place to be is in a situation of supervised recruitment, where for any future ETA 989 labor certification case, or at least for a period of time, the Department of Labor will actually control in a very hand-holding manner, the recruitment that you conduct, right? So they'll say, here's the text of the ad that you need to run, word for word, post it here, advertise it here, and then not only that, have all of the applicants submit their application and their screening questions and their resumes directly to us, the Department of Labor. It's a really onerous process. So that's really just a process that's intended to keep employers honest.
Great. Thank you so much, Louis. We're gonna. So, Louis, obviously, there's a lot of detailed information, many steps and timelines, and just kind of want to cap off this presentation, or the main presentation, just by highlighting how you can streamline the PERM process with technology. Technology in a platform, you can view the recruitment progress, the recruitment files, timelines, just as you mentioned, the status, including actions that are needed from the employer side. And another cool thing about modern technology that can help the PERM process, any questions someone may have, they can, talk with lawyers such as yourself, Louis, for more information or additional questions. So I'm curious, do you have any other insights as to how tech can help throughout the PERM process? Hey, Louis, can you hear me?
Yeah, I can hear you. Sorry, I was on mute for a second. I think
no worries.
There are two things. First is the screen that you're showing here. this applicant this applicant review tool is a great sort of central repository for applicants, right? So instead of having applicants for a position, being directed to, say, send it to some sort of esoteric or, like very infrequently visited inbox, let's say, we have a view into what the applicant's screening question responses are and to the resumes, and then that interfaces to employees, right? So this sort of centralized repository for applicants is great. It's a great feature. And I think it really keeps the recruitment process sort of humming. I think perhaps even more helpful than this is the way in which the platform tracks the important expiration dates in the recruitment process. So as I noted before, dates for recruitment are set forth in regulation very, very clearly. And it's, we used to have a spreadsheet that calculated these dates, right? Like the last possible PERM filing date, the first possible PERM filing date. That spreadsheet has basically been integrated into the platform so that first filing dates, last possible filing dates, recruitment expiration dates, the actual dates that certain ad forms started and ended, that's all tracked in the platform. So that enables us to always stay on top of the dates of recruitment and deadlines for filing PERMs.
Awesome. That's great to hear. Super, super helpful. So with that, I'd like to open the floor up to questions. And we have been getting quite a few questions. So we're going to jump straight into those. Just as a reminder, we can only answer general questions over the air. So Louis and I will also be encouraged, if we don't get to your question, please talk with your immigration counsel for further information. So Louis, a couple questions regarding the COVID-19 pandemic. A few questions are how are companies handling the physical internal job posting?
That's been the most common challenge that we've encountered, and the Department of Labor has published different alerts to, I guess, sort of accommodate these sort of challenging circumstances. Unfortunately, what was conspicuously missing from these alerts is sort of, say, an allowance to post that internal posting notice, say, electronically. They have not made such an allowance. So employers are taking one of two approaches. They're saying, hold off on starting all recruitment, right, until we have a better idea of when some folks will be back in the office. Or they're saying, charge on with the other forms of recruitment. We're confident that there will be a critical mass of employees back at this work site in an amount of time that's sufficient to complete that posting, a paper posting, for 10 consecutive business days, and then to allow 30 more days to pass from then to allow us to then file the ETA 9089. So it's really, there's no consistent approach at this time, unfortunately.
Gotcha. Great. Next question, Louis, are there any examples or say typical reasons for an audit?
Yes, there are, I would say, a half dozen things that I think would trigger an audit. Off the top of my head, a very common one is requirements that are very, very, very high. right? So as we noted in the presentation, it's what's prohibited, employers are prohibited from sort of tailoring the requirements for a position according to what the envisioned beneficiary actually has, right? So the last thing an employer should say is, we're sponsoring Dan, right? Hey, Dan, tell us about how much experience you have, and then base the job requirements on that. So say, like, if an employer were to approach me and say, this is a senior software engineer position, not too senior, let's say, but we require a bachelor's degree plus 15 years of experience, I would respond to that employer and advise them that, this is the Department of Labor will look at this as requirements that are exceedingly high, right? Another example of a potential audit trigger is a foreign language requirement, right? So these are all positions that are located in the U.S. If the sponsored employee, say, is from China, to say that you require fluency in Chinese and Mandarin would be viewed by the Department of Labor, without like adequate explanation, to be prejudicial to U.S. workers, right? It would appear that you're requiring fluency in Mandarin so that this guy so that it's harder to simply weed out U.S. workers.
Great, thank you. Let's see here. Next question, Louis, let me know if this is a good one. Is the job order done by the attorney?
Yes, GIA and my colleagues will typically post that for you, for the employer. However, it requires that an employer actually set up the account and provide us with those login credentials.
Great, thank you. A couple other questions have come in on the total timeline. So, Louis, can you give like a general timeline for the entire process from step one to the final approval of a green card?
Well, the approval of the green card, I can provide a better estimate, really, of the time that it takes to complete these 3 labor certification steps. Because as I noted at one point throughout our discussion, that the total wait time for how long it takes us to start a case until your employee receives a green card in the mail, an actual physical card, it really varies depending on visa classification and where that person is from, right? The focus of today's discussion is the labor certification process. So these preceding steps, how long does it take? If I had to sort of summarize it from the prevailing wage stage, once we file a prevailing wage request, we're looking at 3 to 4 months. The recruitment process, given all of the timelines required, and safe to assume about 3 months. And then once we've completed recruitment and have been able to file the ETA 9089, we typically expect the labor certification to be issued within about 3 to 4 months as well.
All right, thank you. And Louis, do you have time for one more question?
Sure.
Great. Let's see. Sorry, just going through the questions. Please excuse any awkward silences. Lois, you mentioned a 30-day cool-off period earlier. When does that happen?
That 30-day cool-off period starts to run from the end date of the very last form of recruitment, right? So let's say that the very last form of recruitment, you're looking at a grid, right? And there's a start and an end date. You look at the last date of that you see on that grid, right? And then you have to add 30 days to that. And the employer counsel, we cannot file the ETA 989 until those 30 days have run.
All right. Thank you for that. Louis, thank you for taking the time today and taking part in this presentation. Very helpful, a lot of good information. And thank you for answering the questions. To our attendees, thank you so much for joining us today. Just a quick reminder that the recording and the slide deck will be sent out tomorrow afternoon. So please keep an eye out on those links so you can download them. And then just very quickly, I just want to highlight a couple more webinars we have coming up. Thursday, ways to stay proactive with your global immigration strategy, and then next week, maintaining employee well-being during periods of uncertainty. And additionally, there will be a link there. These links you can click so you can sign up for these upcoming webinars or view our existing webinar library. So with that, Louis, again, thank you so much for joining us today. And to our attendees, thank you, and have a great rest of your Tuesday.
Bye, everyone. Thank you.